the Central Belt who doesn't have their Christmas tree up?
I don't have mine's up.
I don't have mine's up.
Oh, great. I'll get for it. I feel maybe it's an HR thing. Maybe it's an HR and Scottish engineering thing.
Not only is the tree up, the lights are out the front of the house. Everything's ready.
Right, there's always one, isn't there? There's one on every call. All Christmas presents bought and wrapped undoubtedly under the tree.
All the Christmas trees up and only the lights are outside the house. That's it.
That is quite impressive, to be fair. I think Sunday might have to be the day where I drag my tree out and put it up. But yeah, the first tree I saw this year was in October in East Kilbride, and I thought, you can take a thing too far. It was a really nice tree, in fact. But I used to do the trick when I was a younger man. I'd just take my tree, and on like the 3rd of January, when everyone's bored with Christmas trees, put a bin bag over it and stuck it in the loft. I can recommend it so that for next year you just batter it out, pull off the bin bag, give it a quick fluff up, and then we go. So I'll get started this morning. Good morning to everyone. This is our, I don't know, for some reason I seem to get this session every year. This is our kind of bah humbug session where we say to people, so you're going to have Christmas nights out, that's fine, good for you, but be careful as an employer because therein lies some degree of peril. It's one of the regular calls to our kind of help desk, I would say, is employee conduct outside the workplace, and specifically round about Christmas, although we'll only talk about that in passing today. It is one of those things, the last couple of years when we had obviously the unpleasantness related to COVID, it was much more minimised because people weren't going out. But this year, I would say we get probably a couple of calls each month about things that happen outside of the workplace that have the potential to have an impact inside the workplace. And we'll talk about what that looks like. And probably most of us, either management or HR, will have at some point cause for concern in relation to an employee's behaviour or attitude or pastimes or proclivities, we'll call it, outside the workplace and or outside the working hours. As I say, very regular call, and if I go through some of the cases that we've dealt with this year over the course of the next half hour, obviously no names, no pack drill, but it is routine and regular. And it's one of those things where I think if you haven't experienced dealing with these issues outside of the workplace, you probably think that the actions that you want to take are much easier than you think. So it may be that you think if someone commits a criminal offence outside of work, that it's a natural consequence that you are entitled to dismiss. So we will know that there are fair reasons for dismissal, things like conduct, capability, etc., etc. But it doesn't necessarily follow that if someone does something outside the workplace that you're not particularly happy with, whether that's expressing views, whether that's posting things on social media, whether that's criminal activity, it doesn't necessarily follow that an organisation can dismiss, even though it's something that you might want to consider. So I shall crack on and go through the technological nightmare of trying to operate slides across Teams. My name's Dermot, if anyone doesn't know. I've been Scottish engineering about 4.5 years. I'd like to think I've been in HR for about 10 years, but it's actually at the thick end of 30. But there's always something new. There's always something that can surprise you, even after 30 years in HR. And I'm part of the Scottish engineering HR and legal team with myself, Kevin, Amy and Lindsay. So I don't know what it is about me that I end up in this session. Maybe I have a bah humbug about Christmas about me. But there you go. I seem to end up doing this session each year. So what we'll cover today is really when we can act and how we can act when we have issues with an employee conduct away from work. And by away from work, I mean in their private life, in their social life, whether it's with other company employees or not, or whether it's a criminal activity, and when we can do something about it and when we maybe want to have a think about it. So probably 20 minutes to half an hour this morning to allow you to get on and do the rest of your day. So I would say that regardless of those people that claim that free expression is getting more and more restricted, cancel culture, all that kind of jazz, the fact is that the rights to freedom of expression and of thought and the rights to hold whatever opinions you like is protected in the law by the Human Rights Act. With those rights, of course, come responsibilities. So whilst you can hold views that any views that you like, the rights to freedom of expression don't mean that we can say what we like, when we like and where we like under the guise of that freedom. There are restrictions on what we can say, which is prescribed by law, and that would be things like in the interest of public safety, public decency, national security, prevention of disorder, or where the expression of views is contrary to other laws, such as those preventing discrimination. That's kind of a long way to say that employees are free to hold views, and within those restrictions we've discussed, free to share those views. The views might well be contrary to widely held views or what's deemed to be acceptable in the general population. And it might also be contrary to our excuse me, company values. So determining whose rights win between an individual and an employer is a pretty delicate balancing act. It's not really our job as an employer, and it's not really our right to make a determination on what people should believe, or how they should profess those feelings, or where, or what opinions they can hold. The kind of old adage holds that we can't change the way people think. We might hope to have an impact on the way that people behave, and through education and through our own value set, we may have an influence on the way that people think, but ultimately people are free to hold whatever views they desire to hold. So most of us on the call this morning, including mine, including Scottish Engineering, most of our organisations will have a value set, and that is kind of generally expressed in words, and it's our hope that our value set becomes not just how we behave internally, but how we're perceived externally. So what people think of us as an organisation. I don't think any organisation, including some of those we'll mention in a minute, I don't think any organisation doesn't care about its own public perception and image. But if you consider that as a concept, most people, or lots of people, will take issues with, as an example, the Amazon employee model. And we've probably read media stories over the past few years about what life can be like as an employee of Amazon in their warehouses, and also their commercial practices. People take issue with their commercial practices. But the fact of the matter is that Amazon remain absolutely unrivaled in what they do in terms of the revenue that they generate, the profits that they make, and the size and scope of their business. I would say the same with companies like Sports Direct, who again have attracted negative media about their own internal employee model and how that works. And obviously, this year, one of the big stories from an employment law perspective was the actions of P&O in terms of effectively dismissing all of their staff and rehiring people on significantly reduced terms and conditions and pay. So whilst a value set is important as an employer, it doesn't necessarily lead, or at least doesn't necessarily lead directly, to commercial nirvana. Having a good value set as an organisation doesn't necessarily lead you to profits. And similarly, the actions of one employee don't necessarily lead to a negative impact on the company. So if you read horrible stories in the media about actions that people have taken, it doesn't necessarily follow that you consider their employer more negative than you did before. And I think there's a view, and I've held this view myself, that if employees do something which is negative, which attracts negative media press, that it will reflect poorly on the company. I don't necessarily know whether that is the case, and it's certainly not the case in that most issues that are reported don't necessarily mention the employer. Excuse me, I'm just recovering from the cold. It might just be a factor of me getting old, or the sensational way that kind of the media talks about media stories at the moment, but it seems to me that the strongest voices in the media tend to be now more at the extremes of points of view which are held. So the kind of middle ground that most people operate within tends to be reported less than people's extreme views. One interesting, I think, journey over the past couple of years has been the Black Lives Matter movement. So a social movement to highlight inequality, discrimination, harassment suffered by Black people. It's matured into a movement which seeks, as it very much should, to influence policy and to positively make an impact on wider population and in our workplaces. It's grown in influence and impact. However, as it's grown in influence and impact, some people have taken the view that it's too strong, that it's become a political movement, and that in promoting the rights of one part of the population, therefore leads to the denigration of the rights of another part of the population. Sounds like someone's tap dancing at the moment. Wonder if that person could go on to mute. Thank you. So I'm really using this example to highlight as access to wider and social media is extended, then the views of those at the wider end of the spectrum can be heard much more widely and with greater impact than a decade ago. The consequence of that is that an expression of views which would not have been possible let's say a generation ago, let's say maybe even a decade ago, is much more likely to affect our employees and potentially involve our employees. And that's something very much to consider. We'll talk about social media a bit more later on. Here, I suppose, is where if you're not aware of this as an employer or working in HR, this is potentially challenging for us to get our heads around, in that it doesn't necessarily follow that if someone breaks the law, that the employer A needs to know or B needs to do anything about it. So except for regulated industries, so I mean things like the care sector, any organisation which works with government assets, so requires kind of PVG or basic disclosure checks, there's no blanket requirement for any employee to inform their employer of any police contact. And that's from being stopped in the street, inquiries, arrests, cautions, subsequent investigation, convictions, right through to sentencing. You may know that in Scotland it's highly unlikely that anyone would be sentenced to a jail sentence of less than a year. So you may well have employees today who are, carrying out some form of supervision order as a result of a conviction, and you wouldn't know anything about it. And as it stands from a legal perspective, you've no right to know unless required by a regulator or by statute. So it's important for us to realise that a conviction for pretty much anything is not in and of itself automatically a reason for dismissal in general, regardless of whether it's an assault in the street or something much more serious, which really challenges our kind of moral compass. And that brings into point, it's really important to separate our own feelings of moral outrage or our organisation's sense of moral outrage from the requirement that we have to demonstrate to a reasonable third party that if we dismiss, that dismissal was warranted. And we'd need to think about what the reason for dismissal would be. So lots of people would say it damages our, by someone's actions, they've damaged the company's reputation. Well, if that person takes us to tribunal, we would be required to demonstrate how it has affected our reputation. And that might be customers have left us, or, we can tie directly a negative impact on the organisation to that person's act. And that's very difficult to demonstrate. Unless a customer phones you up and says, we're no longer going to use you because of the actions of your employee, which you can point to, then it will be a challenge to make that dismissal fair. The criminal justice system doesn't necessarily reflect wider public views on the gravity of one offence against another. It's only recently that, as an example, domestic abuse was separated into more serious categories, I would say, than normal assault in the street. And that's a relatively recent event. So some of the things we've been involved in over the past year, me specifically and other members of the HR and legal team, one of our employees had an employee who was convicted of sexual grooming online with a 13-year-old child. The employee didn't disclose any of the police contact, charge, presence at court, or any of the conviction, and was given a 3-year supervision order, so wasn't in jail, could have turned up at work as was required. Not unnaturally, the news of this became widely known. It was in a fairly rural area of Scotland, and the employer viewed that the continued employment of the employee was incompatible with their own view from a moral perspective, and to protect its good standing in the community and distance itself from the acts of the employee. So the employer kind of presumed when they spoke to us that they could just simply dismiss. Any dismissal, as hopefully lots of us will know, needs to be preceded by, generally an investigation, a disciplinary hearing, or a hearing at which dismissal is threatened, and potential for an appeal. So fortunately in this case, whilst the employer was going through that process of investigation, the employee chose to resign. But it would have been complex, and some of the things which I'd asked the employer to consider is he had told us that some of the employees, the other employees, felt that they didn't want to work with the employee and had voiced that vocally. So gathering that evidence would have been really important in order to justify a dismissal, and certainly in order to defend that dismissal if the dismissed employee had determined to go to tribunal. Another case is quite interesting, not a company in our membership, so I will name them, and not a company in Scotland, and was in the media. A company called Paradigm Precision. One of their employees was pictured holding a White Lives Matter poster at a football match. White Lives Matter is obviously picked up as a corollary to Black Lives Matter, and is viewed as a reaction to to lessen the impact of Black Lives Matter movement. The employer dismissed the employee. One of the factors that led to this being subsequently determined as a fair dismissal is that the company in question had recently been lost a tribunal and had an award made against it of I think £175,000 for harassment within the organisation. And as part of the order from the tribunal and from the Equality and Human Rights Commission, they were required to implement a series of measures in order to minimise the impact of future harassment. And that's a Section 23 agreement, basically, which outlines a legal agreement that an employer undertakes to minimise the effects of harassment within the workplace by, subsequent training, education, dealing with disciplinary matters effectively. So that led to the dismissal. The organisation was quite clear that it probably wouldn't have dismissed had it not educated itself in what it should do in matters like this. The employer was dismissed and subsequently did not pursue the organisation through a tribunal after taking their own legal advice. So just to be clear, to be a fair reason for dismissal, an employee would need to show that the misconduct outside of the workplace justified the dismissal of that employee holding that role. So, some of the other things we've dealt with have been assaults or unwanted touching between employees outside of the workplace. It's potentially easier to demonstrate a line towards the impact that has between employees when they're at work, because not unnaturally, someone who behaves in that way on a night out or someone who is the victim of such behaviour are likely to have difficult working conditions if they're forced to work together. So we need to show that it was justified as dismissal. An employer would need to also show that its decision was reasonable in all of the circumstances, including size and administrative resources of the employee. So it might be that an employer has the potential to move someone's role if they've been convicted of something, or to change what they do, or to change where that they do it. And it should consider those elements before we really get to dismissal. It would need to show that the response and the dismissal, fair reason for dismissal, is likely to be SOSR, an acronym which means some other substantial reason, which is a fair reason for dismissal and really is used when the reasons to dismiss don't fit neatly into one of the other categories. It still requires to be investigated and a hearing held in the same way as anything else. But it would need to demonstrate that the dismissal was in the range of reasonable responses of a reasonable employer. So if someone's done for, effectively winning a fight outside a pub on a Friday night, but it's nothing to do with any other employee, then that would be unlikely to dismiss someone fairly for that. So as an example, we would need to carry out a fair investigation. We'd need to look at what other sanctions we could have implemented short of dismissal, and we should have followed as best we can the ACAS Code of Practice in relation to disciplinary hearings. So when confronted with a situation of an employee facing a charge or a conviction, we should consider whether the conduct or conviction merits action because of the employment implications, what effect it might have at work. In certain circumstances, you might consider suspension pending criminal proceedings, which might affect whether they have the ability to do their job. That's very context dependent, and very specific advice should be sought. I would say speak to us about that. I used to work in the prison service, and we used to have employees who were on suspension for periods of up to 3 years. The criminal justice system acts, but it doesn't act particularly quickly. So in that regard, we need to consider whether suspension is appropriate, or whether we want to act before a sentence is passed, a hearing is held. That's very difficult territory, unless the conduct that we dismiss them for doesn't really depend on whether the person is convicted or not. Our test is whether we reasonably believe something happened, as opposed to the test, in general law, which is beyond reasonable doubt. We do talk about reputational damage quite a lot, and it's one of the things which people who speak to us talk about. In many cases, especially the first one that we discussed, it may or may not have led to reputational damage, but the most immediate concern was the views of employees' colleagues. And we've also had cases where an employee has said to us, or admitted to us, that they couldn't be sure, in another case which related to indecent images on a PC, they couldn't be sure that they could protect the employee if they returned to work from retribution from other people in the community. If those views are represented to the organisation or become known, then I would say it's our responsibility to remind employees, A, of the standards of conduct and the impact of breaching them. But we should gather that evidence, and if that evidence is so great that it leads us to consider that the future employment of the employee in question is incompatible, and if you can view that the views are so great that the potential damage to, let's say, good order, industrial relations, and provide evidence of that, then there is the potential for a fair dismissal. We are not judge and jury, but ultimately we can determine that if someone's continued employment is absolutely incompatible with good order, then it is potentially a fair reason for dismissal. But be aware that in one of the cases myself and Lindsay dealt with a couple of years ago, an employee who was dismissed for indecent images, for being convicted of having indecent images on their PC of children, that the employee was dismissed, and actually, contrary to what I considered might happen, did take the employer to tribunal. You might think that someone would like to keep that as quiet as possible, but that was not the case. Certainly then, they did take the case to tribunal in relation to that issue. So where we consider that criminal conduct might warrant disciplinary action, we should consider this. This comes from a fairly new set of ACAS guidelines on this code on discipline, but a fairly new ACAS code. So from that regard, we should investigate the facts as far as we can, come to a view and determine whether it's sufficiently serious to think about whether we implement our disciplinary procedures, or whether we are building a case to support an SOSR dismissal if this doesn't breach our own internal code. We can consider whether we want to take action in advance of a criminal conviction on the basis that A, they can take years to conclude, and B, that the test is different from an employment perspective. As an employer, if we consider something happened reasonably, if we believe that it happened and it's reasonable for us to believe that it happened, then we don't need to wait for a criminal investigation or hearing, which needs to demonstrate something beyond reasonable doubt. We are beyond reasonable belief, and there's a significant gap between those two tests. So what I would say is, if police are involved, and again this happened to me quite frequently when I worked in the prison service, they're not conducting any investigation on behalf of their employee, and the investigation that they undertake should not form part of our own investigation, because again they will be examining different things and looking for different tests in the law. And as I say, an SOSR dismissal might be the outcome, but we should follow what I would say the standard code of discipline, ACAS code on discipline, which is make sure there's an appropriate, fair and reasonable investigation as far as we can. The individual should have the opportunity for a hearing, the opportunity for appeal if they're subsequently dismissed or penalised. So onto the perils of social social media. There's just a couple of interesting cases on social media that I thought might be interesting to bring to their attention. I would say in general terms, people's conduct on social media is effectively the same as their conduct not on social media. And we'll talk about one of the cases specifically related to Sainsbury's. The company acted differently because something was in social media than they would have done had something happened face to face. And that's generally not considered to be entirely fair. And I kind of agree with that. So one of the cases in Sainsbury's was an employee had taken photographs of a customer who had gone against the hideous one-way systems that exist in supermarket car parks and eventually get caught on a ramp. And the individual, the employee in question, had taken a photograph and posted it onto Facebook with identifying information relating to the member of the public. He was suspended, and he was suspended on the basis that Sainsbury's had formed the view that he had breached their social media policy. So they had a social media policy, and then the issue was investigated. It was investigated for two reasons: bringing the brand into disrepute and breaching its keeping their information safe in their data protection policy. He was dismissed, subsequently dismissed, in a letter saying that he'd brought the company into disrepute. It did not mention that he had breached the social media policy. So as hopefully some of us are aware, how we specify a charge when we invite somebody to a disciplinary hearing is very important, because if you specify a charge and then dismiss someone for something else, or don't dismiss them for that reason, then that's not fair. That is unlikely to be a fair process. So whilst he had two separate charges, he was dismissed for one of those charges, yet most of the evidence that was put forward by the company related to the social media element, and specifically to their data protection policy. So employee tried to appeal to Employment Tribunal and found that although the store manager was aware of alternatives to dismissal, it did not give any more other than superficial consideration to any other sanction. And the individual won their case, and a financial award was made against Sainsbury's, both in relation to their process and the reasonableness of their decision. The dismissal was regarded as unfair. And another issue with the same company, it's a woman called Spence. She had called her boss a young idiot on Facebook. She's a 68-year-old woman and had called her boss a young idiot on Facebook. That's very much on the probably less offensive edge, although there's certainly an age element to it, and no one likes being called an idiot. It's not the most serious of allegations or of statements that someone could make. I suspect that any of us who manage people have probably been called something similar or worse, and maybe that'll happen to us today. She was subsequently dismissed. She told the tribunal that her daughter had created a Facebook account for her, and she thought she was contacting a former colleague privately and posted it on her public wall. She also made allegations that the disciplinary manager was in a romantic relationship with the manager with the young idiot, let's say. The tribunal found that while Sainsbury's had lots of policies in relation to this, that the individual employee had never had any training on it, such as social media guidelines or indeed equality, diversity and inclusion in relation to the kind of age element. And it was clear that the manager said that either the disciplinary manager stated that HR had said to him that his actions or his decision will either be no action or dismissal, and the tribunal found that the dismissal was inherently unfair. It's also important to note that Sainsbury's admitted that had the statement been made face to face, so had the employee called the manager a young idiot to their face or even in front of other people in the workplace, it's unlikely that they would have dismissed, and therefore the concept, whether it's in social media or not, and could in theory be viewed by tens of thousands of people in theory, should not have added weight to the allegation. Secondly, Ian McWhirter is a fairly well-renowned journalist at the Herald, or certainly was, and had been for about 25 years, very well renowned and experienced. But when Rishi Sunak announced his new cabinet earlier this year, it's difficult to remember which one that was, I think it's the current one, he had tweeted the phrase in inverted commas, and I apologise if this does offend people because there's a pejorative term in here, but he tweeted the phrase "a coconut cabinet" and a question mark in relation to the cabinet. If anyone doesn't know, coconut is a pejorative term which would be levelled at people of colour who are regarded by other people as acting white, and I'll use that in heavy inverted commas, that is the term which is used, hugely offensive. Mr McWhirter claimed that he was using the phrase ironically, and he was using hyperbole to make some kind of ironic point, and he was subsequently dismissed, and he has written fairly extensively subsequently after that. And the last one is when companies try to, in their own view, probably do the right thing, and shoot themselves massively in the foot. I won't name the company involved in this. It was an advertising and marketing company who, as part of their advertising campaign, and this was this year, the managing director made a statement, as noted there, we don't hire blacks, gays or Catholics, we hire talented people and don't care about colour, sexual orientation, etc, etc. That's one of those phrases that probably sounded good in his head to say that, you know, the second part of it's fine, we hire people regardless of that, but it does sound fairly pejorative and fairly negative, and it eventually led to the managing director stepping down from that organisation. So it's clear that social media has a potential to meet the factors necessary for dismissal if you can be bullied across social media in the same way as you can be bullied in the workplace. So, you know, employees can bully each other across social media. And therefore, if it meets the factors necessary for dismissal, then we should pass the same tests as we've noted before. Dismissal, is it fair? And what grounds are we basing that assertion? What is the impact? How have you dealt with it? Do a proper investigation, a proper hearing, and if there is the right to appeal, then the right to appeal. The fact that something is on social media doesn't make it more or less serious. It has a potential to have a wider impact. But once again, sometimes if people post, you know, I don't like my boss or the company I work for is terrible, it's likely in the employer's gift that we will overestimate the reputational damage that has caused. Lots of people don't like their employers. Lots of people don't like their jobs. The fact that we are named is an issue, but it doesn't necessarily lead to reputational damage. And the fact that someone voices something in social media that they could have told their pal down the pub doesn't really change massively the impact of that, unless we can demonstrate that it does. So just lastly, this is our Bah Humbug annual Christmas message. So it's a time to have fun, but not too much fun, and fun in a very controlled way. In certain cases, the conduct of our employees at nights out can have it can be actionable at work. It's something we need to consider. We've done a number of examples this year, some humorous, some very not humorous, when behaviour outside the work has led to disciplinary issues within work. And that could be, as I say, unwanted physical contact, suggested statements, assaults, all of these things that can happen when drink is taken. But these happen away from the office. It doesn't matter really necessarily whether something is an official night out, so your organisation's Christmas night out, or whether it happens between employees who are out on their own night out. If it is an impact in work, then it's something that we need to be aware of, and it's potentially something that we need to do. The impact of those actions can have a detrimental impact in the workplace, and we need to be ready to deal with it. So whether it's official doesn't really matter. It's whether it has an impact in the workplace. So if that is the case, if that's something which happens to us and which has been brought to our attention, then this is what we need to really consider. So does it relate to their employment role, or is it relevant to the employer's business? So, is this something that is going to damage your reputation? Is this something which damages the views or the feelings of another employee? Is it something which will impact, let's say, if someone does something which is who's in the care sector or provides care to other people, does it materially impact their ability to do the job? Can they carry out their duties? Is there sufficient damage, demonstrable damage? We can't say it damages their reputation if we think that it might. We need to demonstrate that damage to reputation has actually happened, or damage to business or good order within the organisation. Is there an ongoing risk? So if people are convicted of, let's say, offences which are, let's say, sexual in nature, does that lead or will that lead to difficulties in that person's compatibility in the workplace, or people who they work with feeling less safe than they did before? We need to consider, as we always need to really do when we're considering dismissal, is it appropriate? Could we do something else which would achieve the objective of rectifying behaviour? What's proportionate and what is reasonable? In regulated industries, care sector issues, that the health, the criminal justice sector, do we need to notify the regulator of that? And if that regulator determines that they take action, so withdrawal of a license, withdrawal of a right to work, what does that mean for us in relation to ongoing employment? So if someone's banned from driving and their principal part of their role is driving, then it's a consideration for dismissal. If someone has a non-harassment order, as we've dealt with, where they're not allowed to harass or approach another person who is an employee of your organisation, how do we deal with that? And if that ultimately leads to we cannot comply with the orders which are placed upon this individual if they're in the workplace, then that's potentially a fair reason for dismissal. So from an organisation perspective, it's always worthwhile reviewing your code of conduct to see whether how we deal with activity outside of the workplace is noted. And if it's not, then it's worthwhile making sure that employees are aware that just because something happens outside the company gates doesn't mean it doesn't have an impact on work. I would give consideration to social media policy or guidelines. It's not something I generally get myself massively involved in when I had a real job, because in terms of social media, the same restrictions that apply on people's conduct apply online and offline. So bullying, harassment, doesn't really matter whether it happens on or offline, it can be covered by our internal procedures. But social media policy is helpful for maybe guiding people on how they conduct themselves on any of the social media platforms which people use. And again, when we're considering our code of conduct, we need to consider whether how we want people to behave is reflected in our disciplinary policy to make sure that people go out with the scope of our code of conduct, that we can do something about it. So that is me finished. Does anyone have any questions? There are silences, everyone's disappeared, or I've covered so much that people have no questions, or people are eating their breakfast. If anyone has any questions in relation to this, by all means, contact ourselves, contact me, and hopefully all of our contact details. But if no one's got any questions or not covered, then I'd like to thank you for your presence this morning. And if I don't speak to any of you before, I hope that you all get the opportunity to have a peaceful and restful Christmas, ready for whatever delights 2023 has got to offer us. So thanks very much for this morning, and we will see you in January.
Thanks, Dermot.
Thanks.
That was really
Cheers.
good.
Thanks.
Have a
Bye-bye.
good Christmas yourself.
And to you. Cheers.
Merry Christmas.
Thanks, all the best.
Cheers. Bye-bye.